Folks, it is the 1st of June, which means Supreme Court decisions coming down. 3 rulings were issued today by the Supreme Court. Let's go right to Ellie Mitchell, Justice Correspondent for The Nation, who can explain to us exactly what happened. Ellie, always glad to see you. Let's first start off with this labor case. What was the case about? What did the Supreme Court decide?
Yeah, so the right to strike, kind of an important tool in labor's arsenal against corporate interest and corporate greed, that was severely vitiated today at the Supreme Court. The case is called Glacier Incorporated versus Teamsters. Basically, the Teamsters union walked out on the job of a cement company, right? They poured the cement, they put it into their trucks, the Teamsters drove the trucks away to start the deliveries. Around lunchtime, the Teamsters called for a strike. So instead of delivering the cement, they drove the trucks back to the lot and left the trucks running and walked off the job. Well, if you know anything about cement, you know it tends to dry and harden. The cement dried, some of it dried and hardened, some of it damaged some of the trucks. After the strike was over, Glacier, the cement company, sued the Teamsters union for economic damages for the lost cement and the damage to the trucks. Now, in normal situations, that case gets thrown out on its ear. And in fact, when they sued in Washington State Court, the Glacier is the cement company is from Seattle, it was tossed out on its ear. But the Supreme Court revived the case, and today, by a vote of 8-1, with Ketanji Brown Jackson being the only dissenting justice, the Supreme Court said that the cement company could, in fact, sue the Teamsters for economic harm for their strike.
Okay, so explain 8-1. That's interesting because you got 3 so-called liberal justices, and so what the hell happened here?
Yeah, I mean, I'm kind of, excuse me, I'm kind of grasping at straws to understand what was in the minds of Sotomayor and Elena Kagan when they voted along with this decision. Because make no mistake, if you can sue, look, the point of a strike, right, is to cause economic harm to your employer. And while everybody understands,
right,
you can't walk out on the job and set fire to the building on your way out. Everybody kind of understands that. But causing some kind of economic pain to your employer is literally the point of a strike. And if the company is then able to sue the union in this case, every time there's economic harm based on a strike, it just curtails the ability of unions and workers to organize and cause that economic pain to get better deals at the negotiating table. Why did the other 2 liberals join with the 6 conservatives on this case? Well, I think I'm going to be nice to them and say that what they were trying to do is mitigate harm. Legally, there's a technical issue about whether or not the National Labor Relations Board gets to hear this case first. Usually, the National Labor Relations Board would get to decide before the Supreme Court. In this particular case, the conservatives said that they could interpose themselves before the NLRB. But Justice Thomas and Justice Gorsuch, and to some extent Justice Alito, would have basically disagreed with the NLRB's right to exist. And so if those 3 had held sway on the Supreme Court, the decision would have been far, far worse. And it's possible that Sotomayor and Kagan went along with, Barrett, who wrote the majority opinion, Amy Coney Barrett, and the other kind of more moderate conservatives, simply to mitigate the harm that Clarence Thomas and Neil Gorsuch were trying to do. That's my best answer for them. But the other, I think, upshot is that by being an 8-1 decision, it kind of let Ketanji Brown Jackson loose to write, so far, the best dissent of this term. Her dissent, put like this, her dissent is longer than the majority opinion and some of the concurrences combined. She went all in on how terrible this decision is and how if the court had should have had basically the humility to allow the NLRB to make the ruling first before the Supreme Court stepped in and ruled on the side of the corporations. It was a brilliant dissent that she was free to write, in part because, hey, she was a lone dissenter, so, she shot her shot.
And well, of course, and as usual, Clarence Thomas, full of crap, pretty much saying, why even have a National Labor Relations Board?
Yeah, his argument was that the deference that we normally give from the NLRB should not exist. And let me just quickly explain why does the NLRB exist, right? Why is there a National Relations Board? Well, because there's a National Labor Relations Act which protects the right to strike, and it protects it on a national level, so that when it comes to striking workers, you're not supposed to have to worry about whether or not you're in Illinois or California or West Virginia or Ron DeSantis stand in Florida. You're supposed to have a national protection for workers' rights and for the right to strike. And that is the heart of what this decision goes at. It takes away, and Thomas would have completely taken it away, Barrett severely weakens that national protection for the right to strike, and instead leaves it up to state by state by state to determine kind of which damages are going to apply. And you can imagine how hard this is going to be going forward for labor organizers. You can imagine, I don't know, writers striking in California. Now, instead of availing themselves to the National Labor Relations Board, they might be sued in California, in a California state court, over grinding Hollywood to a halt. You can imagine coal workers striking in West Virginia. If you're a coal worker in West Virginia, who do you want to hear your strike? The National Labor Relations Board or some state court judge in Huntington, West Virginia, right? So by taking it back down to the states, what they've really done is, again, severely weaken the right to strike for union organizers and workers all across the country.
All right, folks, back to that Roland Mark Unfiltered video in just one moment. When you talk about blackness and what happens in black culture, we're about covering these things that matter to us, speaking to our issues and concerns.
This is a genuine people-powered movement.
There's a lot of stuff that we're not getting. You get it, and you spread the word.
We wish to plead our own cause. Too long have others spoken for us. We cannot tell our own story if we can't pay for it. This is about covering us. Invest in black-owned media. Your dollars matter. We don't have to keep asking them to cover our stuff. So please support us in what we do, folks. We want to hit 2,000 people, $50 this month, raise $100,000. We're behind 100,000, so we want to hit that. Y'all money makes this possible. Check some money orders. Go to P.O. Box 57196, Washington, D.C. 20037-0196. The Cash App is $RM Unfiltered. PayPal is R Martin Unfiltered. Venmo is RM Unfiltered. Zelle is Roland at RolandSMartin.com.